Over the weekend, one of my subscribers asked me to make a video about Judge Dugan. So, did a state court judge break federal criminal law and assist an illegal alien in escaping ICE? I'm going to let you guys be the judge. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. A subscriber asked me to talk about the case of this Milwaukee state judge, Hannah Dugan, who was arrested for aiding and abetting the escape of a deportable alien. The alien was a previously convicted criminal and was in court for domestic violence charges. ICE was there with a valid administrative warrant because he had previously been deported. I'm going to attack this from as apolitical a view as possible since there are concerns on both sides of this issue that have some merit. Before we begin, I should note that no one in the media has covered themselves with glory in reporting on this situation. I've seen reports that Hannah Dugan, the judge at issue, is a federal judge. She is not a federal judge. She is a state court judge in the Wisconsin court system. I've seen a lot of politicians on one side of the aisle who are weighing in and deciding that the judge is guilty and ought to be hung, drawn, and quartered and buried in an unmarked grave. That's hyperbole, by the way. There are some people who don't seem to get that I do that every now and then. On the other side, there are politicians calling for other judges to engage in the same criminal misbehavior. Neither side are being champions for the rule of law with this kind of rhetoric. At the outset, Judge Hannah Dugan is innocent unless and until she is proved guilty in a court of law. Americans do not prejudge criminal cases before trial. She is entitled to due process and she will receive it. Because this case touches both on the criminal law as well as the judge's fitness to sit on the bench in Wisconsin, I think the first thing we need to look at are the key ethical standards for a Wisconsin judge. So this is SCR Chapter 60 from Wisconsin. It is the Code of Judicial Conduct. And in the preamble, it sets out a couple of things. It says when the text of a rule uses shall not, or may not, it is intended to impose binding obligations, the violation of which can result in disciplinary action. For a judge's conduct to constitute a violation of the rule, a judge must have known or reasonably should have known the facts giving rise to the violation, which is only fair. Then we come down to the definitions, and there's really not anything there other than this one that seems to apply. Impartiality means the absence of bias or prejudice in favor of or against particular parties or classes of parties, as well as maintaining an open mind in considering issues that may come before the judge. Again, sounds pretty fair. Then we come down to the first of the canons. A judge shall uphold the integrity and independence of the judiciary. And the key thing there is a judge should participate in establishing, maintaining, and enforcing high standards of conduct and shall personally observe those standards so that the integrity and independence of the judiciary will be preserved. In other words, Wisconsin doesn't want its judges running up and giving the judiciary a bad name. Again, that's fairly standard. The one that probably applies with greater force here is 60.03. A judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities. A judge shall respect and comply with the law and shall act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. And it goes on in the comment to say actual improprieties under this standard include violations of law, court rules, or other specific provisions of this chapter. The test for appearance of impropriety is whether the conduct would create in reasonable minds a perception that the judge's ability to carry out judicial responsibilities with integrity, impartiality, and competence is impaired. So, those are the standards that a Wisconsin judge is held to. You can find this online by Googling Canons of Judicial Conduct Wisconsin, and this will pop up. It's chapter 60. Now let's look at what the judge is alleged to have done. This is a sworn affidavit from the FBI agent that was involved with investigating this, or one of them. And keep in mind, these are allegations. They have not been proved. They are simply allegations at this point. They form the basis for the criminal complaint against the judge. So this is the affidavit of Lindsay Schlimmer, who is an FBI agent, says she's been with the Bureau since 2014, is also a certified public accountant and worked as a CPA before, joining the FBI, currently assigned to the White Collar Crime Squad, public corruption crimes, participated in those kinds of criminal investigations, including facilitation of payments and kickbacks, and she has done, among other things, executing arrest warrants. The agent says they base the affidavit upon personal knowledge and upon information reported to them by the federal law enforcement officers during and as a part of their official duties, all of whom they believe to be truthful and reliable, and also on witness interviews as described below. So, the affidavit is intended to show that there is probable cause for the requested criminal complaint and does not set forth the complete knowledge regarding the matter. So, public records showed that Eduardo Flores Ruiz was charged in Milwaukee County with 3 counts of battery, domestic abuse, infliction of physical pain or injury. So, agents from DHS, the ICE Removal Operations Bureau, identified Ruiz as an individual who was not lawfully in the United States. He's a native and citizen of Mexico. And Flores Ruiz had been issued an I-860 notice and order of expedited removal by the United States Border Patrol back in 2013, and that Flores Ruiz was thereafter removed to Mexico through the Nogales, Arizona port of entry. There's no evidence that he ever sought permission to return. The Milwaukee ICE ERO office determined through biometric fingerprint comparison that the fingerprints of the individual charged in the Milwaukee County case matched those of Eduardo Flores Ruiz. And then on April 17th, an authorized immigration officer found probable cause to believe that he was removable, and they issued a warrant that said you're commanded to arrest and take into custody for removal proceedings under the Immigration and Nationality Act, the above named alien on the warrant. Upon his arrest, he would be given a notice of intent, decision to reinstate prior order, and he would then have an opportunity to contest the determination by making a written or oral statement to the immigration officer. The Milwaukee ICE ERO was aware on April 18th that he planned to attend this criminal hearing and that Hannah Dugan was the judge and that it was going to be at the Milwaukee County Courthouse. I'm aware that law enforcement routinely executes warrants and makes arrests in public areas of buildings like the courthouse because the wanted individual would have entered through a security checkpoint and thus be unarmed, minimizing the risk of injury to law enforcement, the public, and the wanted individual. So they showed up to execute on the warrant. And the agent says they're aware of 2 prior arrests in the area of the courthouse complex. Both incidents involved individuals who'd been charged with criminal offenses but were not in custody. The task force was focusing its resources on apprehending charged defendants making appearances in criminal cases and not arresting victims, witnesses, or individuals appearing for matters in family or civil court. 6 members of the ERO task force planned to take part. There were 2 FBI agents, 2 DEA agents, and 1 border protection and 1 ICE agent. So a total of 6. At approximately 8 a.m., they went into the courthouse. They told them that they were there to present to make an arrest. Shift sergeant from the Milwaukee County Sheriff's Office was contacted. Sergeant asked that any arrest wait until after the scheduled hearing, and they were allowed to go up to courtroom 615. The other members of the arrest team were already present on the sixth floor when the deportation officer and the CBP officer arrived. FBI agents A and B had advised the courtroom deputy for 615 that law enforcement was there to arrest Flores Ruiz. They agreed that the arrest would take place after Flores Ruiz's court appearance. The agents then left the courtroom and took positions at different locations in the public hallway. Case agents have interviewed the courtroom deputy present in courtroom 615 on April 18th who corroborated the above information. So she went through all of that and said, accordingly, the courtroom deputy notified a shift sergeant as was required by policy. Arrest team members reported that while waiting outside the courtroom, a woman approached and took photos of arrest team members. It will later be revealed that at least one of the women who was in there was the attorney for Flores Ruiz. DEA Agent B, who was inconspicuously seated away from the group, was not photographed. The individual taking photographs of the agents had been identified by multiple witnesses as an attorney employed by the state of Wisconsin Public Defender's Office. Team members observed Flores Ruiz arrive on the sixth floor of the courthouse at approximately 8:43. Greeted by his attorney, two entered courtroom 615 together. Witnesses have described Judge Dugan's response to learning of ICE's presence. For example, the courtroom deputy indicated when Flores Ruiz arrived, Judge Dugan was already on the bench. The courtroom deputy observed Attorney A, the individual who had photographed the agents, enter and approach Judge Dugan's clerk. Attorney A stated that there appeared to be ICE agents in the hallway. The Attorney A told the clerk that agents were there, that were seated, and what they were wearing. The courtroom deputy reported that the clerk got up and told Judge Dugan, and Dugan became visibly angry, commented that the situation was absurd, left the bench, and entered chambers. At the time, Flores Ruiz was seated in the gallery of the courtroom. Another individual, Attorney B, was working as the assistant district attorney in her courtroom. According to Attorney B, there were approximately 8 criminal cases, including Flores Ruiz's, and they were scheduled for pretrial hearings. While Attorney B was preparing for that morning's docket, Attorney B heard someone say, "ICE is here." Attorney B heard Judge Dugan say that she was going to call the chief judge before leaving the courtroom. Now, I think that's kind of important. And the reason I think that's kind of important is because you'll see some of what the chief judge does in this is delay other officers so that there would not be the same, the number of, they brought 6 to make sure they could control the guy. And he is holding 2 of them in his office, talking with them about some of these issues. Whether or not he did that with some kind of intent to, stop them from getting a hold of Ruiz is not known, but it certainly looks bad for that chief judge, at least in my opinion, it does. The agent goes on to note that members of the arrest team reported that Dugan was very angry and that she was visibly upset and had a confrontational, angry demeanor. She addressed Deportation Officer A and asked if he was present for a court appearance. He said no. Judge Dugan stated that he would need to leave the courthouse. You may be well aware that courthouses are public buildings and courtrooms are public. People can come in and view trials at any time they want to. That's a public building, and they are more than able to stay in. They could go in the courtroom if they wanted. They were staying outside the courtroom as a courtesy to the judge and the other litigants. But they absolutely had the right to go into the courtroom because courtrooms are open to the public. And if they're open to the public, they're open to the deportation officers as well. So Judge Dugan asked if the deportation officer had a judicial warrant, and the deportation officer said, "No, I have an administrative warrant." Judge Dugan stated the deportation officer needed a judicial warrant. Deportation Officer A told Judge Dugan that Deportation Officer A was in a public space and had a valid immigration warrant. Judge Dugan asked to see the administrative warrant, and the deportation officer offered to show it to her. She then demanded that he go speak with the chief judge. Judge Dugan then had a similar interaction with FBI Agent B and CBP Officer A after finding out that they were not present for a court appearance, and that they were with ICE. Judge Dugan ordered them to report to the chief judge's office. The judge had absolutely no authority to order the FBI agent or the CBP agent to do anything because they were there on official business. And at that point, she doesn't control them. Now, in her courtroom, when she's on the bench conducting the trial, she can certainly order them out. But in this situation, she stepped over the line. She doesn't have the right to tell them to leave the courthouse. They weren't causing any kind of disturbance or anything like that. Now we meet another player in this drama. Judge A then escorted the members of the arrest team away from courtroom 615 through a set of double doors toward the reception area for the chief judge's office. DEA Agent B, who was not recognized by Judge Dugan and Judge A as being part of the arrest team, remained behind outside of courtroom 615. The courtroom deputy observed a portion of the above described events in the hallway. According to the courtroom deputy, shortly after Judge Dugan was advised of ICE's presence, the courtroom deputy left the courtroom to look for an unrelated defendant whom the courtroom deputy was seeking to arrest on an open warrant. The courtroom deputy saw Judge Dugan in her robe in the public hallway telling the federal agents he needed to go talk to the chief judge. Judge Dugan appeared visibly angry and was walking quickly. As soon as the agent entered the chief judge's vestibule area, the courtroom deputy saw Judge Dugan walk south down the hallway and enter a locked door near courtroom 615. The agent says, I am familiar with the court floor plan for the 6th floor of the courthouse and believe that Judge Dugan entered a door that led to a non-public hallway from which she could access her courtroom and chambers. DEA Agent B, who had remained in the hallway and had not been recognized as a member of the arrest team, reported that Judge Dugan walked around the hallway and appeared to be looking for additional agents before she returned to her courtroom. Once inside the office of Chief Judge, Deportation Officer A showed Judge A his credentials and the administrative warrant. Judge A asked the Chief Judge's clerk to make a copy and asked whether the Chief Judge was available. The clerk advised the Chief was not in the building, but later advised that he was on the phone. At that point, Judge A left and the deportation officer went inside a more private area of the judge's office to speak with him on the phone. During their conversation, the chief judge stated he was working on a policy that would dictate locations within the courthouse where ICE could safely conduct enforcement actions. When the judge expressed interest in talking to the ERO management about the policy, the deportation officer gave him that information. While Deportation Officer A was speaking with the chief judge, DEA Agent A, CBP Officer A, FBI Agents A and B waited in the vestibule outside the judge's office. DEA Agent A departed the area after a short while. Judge Dugan's courtroom deputy then approached the remaining arrest team members and stated that the courtroom deputy was not the one who notified Judge Dugan about their arrest plans. The courtroom deputy also made a comment about Judge Dugan pushing Flores Ruiz's case through, which the arrest team interpreted to mean that Judge Dugan was attempting to expedite Flores Ruiz's hearing. Multiple witnesses have described their observations after Judge Dugan returned to her courtroom. The courtroom deputy recalled that the courtroom deputy's return to the courtroom, defense counsel for Flores Ruiz was talking to the clerk, and Flores Ruiz was seated in the jury box rather than in the gallery. Defense counsel and Flores Ruiz then walked toward each other and toward the public courtroom exit. The courtroom deputy then saw Dugan get up and heard Dugan say something like, "Wait, come with me." Despite having been advised of the administrative warrant for the arrest, Judge Dugan then escorted the man and his counsel out of the courtroom through the jury door, which leads to a non-public area of the courthouse. These events were unusual for two reasons. First, the courtroom deputy had previously heard Judge Dugan direct people not to sit in the jury box because it was exclusively for the jury's use. Second, according to the courtroom deputy, only deputies, juries, court staff, and in-custody defendants were being escorted by deputies could use that back jury door. Defense attorneys and defendants who were not in custody never used the jury door. Judge Dugan forcefully motioned for the attorney and a male she didn't know to approach. Flores Ruiz's attorney appeared to be confused by the gesture, but complied with the directive. Judge Dugan commanded them to leave through the back door of the courtroom. Attorney B then saw Judge Dugan escort Flores Ruiz's attorney and the male through the non-public door near the courtroom's jury box. Shortly thereafter, Dugan came back to the courtroom and conducted hearings on the morning's docket. Attorney B learned that Flores Ruiz's case had been adjourned. This happened without Attorney B's knowledge or participation. And remember, he's there representing the state. So they heard from the victim witness specialist, and she was concerned because the victims were there in the courtroom. Judge Dugan, she said, Attorney C, who was in the courtroom, said Judge Dugan forcefully directed two people to leave through the jury door. Attorney C indicated this was done with a stern tone. After leaving the chief judge's vestibule, the DEA agent A reported that Flores Ruiz and his attorney were in the public hallway. DEA agent B also observed Flores Ruiz and his attorney in the hallway and noted that Flores Ruiz was looking around the hallway. From different vantage points, both agents observed Flores Ruiz and his counsel walk briskly toward the elevator bank on the south end of the sixth floor. And then they were not the closest elevators to room 614, and it therefore appears that Flores Ruiz and his counsel elected not to use the closest bank. While on the elevator, Flores and his attorney spoke to each other in Spanish. They exited the elevator on the bottom floors of the courthouse and used the 9th Street public entrance exit to leave the building. So then the DEA agents rounded them up and they communicated that to Deportation Officer A and CBP Officer A, and they were still talking on the phone to the chief judge when they were told that he had been arrested outside the courthouse. So there you have it. That's what the FBI agent said. That's what the complaint charges the judge with. Is she guilty? I don't know. Right now, she's innocent. She's presumed innocent. Will she be found guilty? Again, I don't know. If they can establish all of that, then most likely yes. But nobody knows for sure. Let me know if you want me to break down the elements of those two charged offenses and anything else that you think might be of interest. Otherwise, I think we have done a pretty full breakdown on what has been charged. We'll have to see how this moves through the courts, and I will follow it whenever there is any substantive news out about this particular case. I want to thank whoever asked me to do this. I hope you found it to be relatively politics free. I have tried to be as unbiased as I can be in this situation. I have to state on the record that I do believe that people who are here illegally should leave voluntarily. That's my preference. And if they don't, they should be deported. And then the second they get on foreign soil, they should immediately apply to come here legally and lawfully, and I would welcome them then with open arms. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.